everyone, and welcome to another episode of the Business Growth Show, where we talk about all components of business and how to utilize them for exponential growth. My name is Ethan Cassiotis. I'm a business growth expert who helps business owners grow and scale to create wealth and freedom. And today, I have an awesome guest. She's the founder, owner, and director of TAR Law, where she protects your intellectual property. She has worked with multinationals such as Microsoft, General Motors, Instagram, Unilever, Universal Music, and more. And she has a Bachelor of Science majoring in genetics, a Bachelor of Laws with first-class honors, and a Master's of Industrial Property Law. And she is admitted as a patent and trademarks attorney, a solicitor in the state of Queensland, and an attorney in the state of New York, USA. She has worked for top-tier firms such as Allens and Minter Ellison and taught at Bond University. She helps people with their trademarks, designs, patents, plant breeders' rights, copyright, and domain name matters. Welcome, Hayley Tarr, and thank you for being on my show.
Thanks, Nathan. Thanks for your intro.
Yeah, you're very welcome. I'm sure it's going to be awesome today with everyone watching and listening. So, firstly, you're a very successful entrepreneur. So, for those people who don't know who you are, please introduce yourself by telling us about your journey.
Well, I started my firm in January 2020, so it was right before COVID hit. But in some ways, it was a bit lucky because I was working from home when I started my firm, so it really didn't impact me in that way. I could just continue doing what I was doing. And I was lucky enough that my trade is something that you can pretty much do all online. You didn't really need face-to-face contact with clients. I do meet up with clients. Last night I had a drink with a client, but it's not really a requirement of the job. It's just something that I tend to, over the course of working for clients, become friends with them because you feel like you're part of the team, and then you genuinely care about their business and you want their business to go well and all of that. So we make friends, but it's not essential. I can do it all online, and so that was something that was lucky, I suppose. It meant that, especially also being on the Gold Coast where COVID wasn't as much of an impact, that I really feel, and this is probably bad to say because everyone else who experienced a lot more of the consequences of COVID would hate to hear this, but it really did not feel like this huge deal that everybody else experienced it as. The only real impact that's been happened for us on the coast is that property prices just skyrocketed through COVID. But other than that, it wasn't a big thing here. But yeah, so over the course of that time, I started working at the beginning, doing some white label work and working for other people that I knew from being in the industry for a long time, and then slowly but surely, built up my client base through referrals from other solicitors and from accountants, and then repeat clients. So it's sort of just grown organically, I suppose, to date. And the plan is for it to continue to grow. I hear that in the first 12 months is a little bit of a milestone, and then the next milestone is like the 3-year mark. So I've hit that one, and now I'm looking to that 5-year mark to just say, okay, yeah, the longer the business continues to operate, the sort of more secure in a way that you feel you are.
Yeah. Awesome. Yeah, great story, and interesting times to start just before, but luckily that, like you said, the working from home thing worked for you. And it's interesting where people lived, how it affected people differently. And I think it's a mindset as well about it could be doom and gloom, just like in business, right? Whatever's happening, whether it's a pandemic or whether it's just generally challenges like with inflation, interest rates, or whatever that's happening at the moment. But it's the mindset behind it of it's all good. We'll just keep moving on. So I love those elements of the story there. And congrats for 3 years.
That's also something about intellectual property as an industry, because it's a little bit like, if you're a trader, you can't lose, because if the market's volatile, you can make money on the way up or you make money on the way down. Like, intellectual property is like that in a way, because if people are under pressure, then they tend to become more innovative. They have to pivot. A lot of businesses that were doing one thing, they couldn't do that anymore, so they had to start doing something else, and therefore they needed trademark protections for those new industries that they were moving into, etc. So even when there's problem in the market, it's never sort of bad from an intellectual property perspective, because problems also cause innovation. So yeah, in some ways, it's not an essential thing. It's not like, well, if you're sick, you've got to go to the doctor, you've got to spend money on that. Some people, if inflation's high, they'll think, oh, well, I've got to cut something. Maybe I won't register a trademark because it's not essential. But in the flip side, even though it's not essential, it is something that's always there. It's part of the mix.
Yeah, I like that. Always opportunities on both sides, which is very, very interesting. Very good way to think about things. So yeah, let's get into trademarks now, because it's a big thing that people want to know about. It's important in business. So firstly, what can we trademark?
Yeah, we can trademark anything that operates as a badge of origin for your business. So in the Trademarks Act, it's called a sign. That can be anything from a shape, a sound, scent, a color. But most commonly, it's a word or an image, like a logo, and then sometimes we call it like a composite mark, where you have the word and the logo together. So I can see on yours, you've got Athen Cassiotis, and you've got your little head with the brain, sort of swirly brain. So that would be Athen Cassiotis. You could register as a word mark. You could register that little logo in the middle separately as a logo. You could register it together as a composite mark. So yeah, that's basically what you can register.
Nice.
Yeah.
So then following on from that, right? Because some people are like, maybe they're at the start of their business, or maybe their business has been going on for a while, but what are really the benefits, right, of registering our trademark or trademarks?
Yeah. So, well, the key thing is that you then are protected, because you'll have a defense to an allegation of trademark infringement by somebody else if you're using a mark that you have registered for the goods and services that you have it registered for. So it doesn't protect you from an allegation of passing off or misleading and deceptive conduct, but it does protect you from at least that allegation of trademark infringement, so that once you set up shop and you've got your website up and running and all your social media going and your SEO is getting optimized and everything, and then suddenly someone comes along and says, hey, that's trademark infringement, you've got 14 days to take it all down, and then all that goodwill that you've generated, everything that you've done, you have to scrap and start again. So it's just sort of like number one, it protects you from that risk of investing all your time and energy and money into something that you then have to do it all over again from scratch. And if you do, and you've got motivation to do that, great. But some people, that can just be the end of them, because they just can't bear having to start it all over again. So that's key. That's really making sure that you've got that freedom to operate. And then the other thing is for you to be able to stop other people, because if you don't have a registration, then you can allege passing off and misleading and deceptive conduct. But that, to prove those things, you have to have a reputation. And, that's not a given. The other person can say, well, you don't have a reputation, or your reputation's limited to these particular goods and services. Your business plan might have been to start building a reputation in other goods and services in 1 year's time, but you haven't done that yet. So you can't stop me for those goods and services yet, or your reputation might be geographically restricted. So you can only stop me from doing, the Business Growth Show in Sydney, because that's where you have a reputation. But I'm going to set up my own one on the Gold Coast, and you don't have a reputation here, so you can't stop me. So it just gives you that ability to stop someone from doing something Australia-wide in relation to all of the goods and services that you've got covered by proving that you've got a registration, which you just need to say, here it is, that no other evidence is required, like proving, you know, you've got a reputation and so forth. And because of that, it means you've got a lot easier avenues to get things stopped. So, you know, you could file a domain name dispute with OUTA, for example, and, you know, if somebody's using a domain name to provide a service when the domain name's the same as the registered trademark you've got for that service, you can, you know, lodge that domain name dispute and get that domain name transferred to you. You can lodge a takedown notice with, you know, Facebook, Instagram, any of those, and just say, look, this person's using my registered trademark for, you know, providing these services on Facebook. So I want that page taken down or that content removed. No, but if you don't have that registration, it would be up to them to look at it and make a decision whether you had a reputation and whether this was passing off. And that's a big legal thing. They don't want to get involved in that. So they need that sort of piece of paper. So it gives you more avenues to protect your rights and to do it quickly and cheaply. And then the other thing is, you know, value. I was just looking up before we chatted about some of the most valuable brands. I mean, I think Amazon's comes in number one at the moment at about $300 billion US. Obviously, no one listening to this that in Australia at all is going to have a brand that's worth that much. But the intellectual property and the brand is a huge part of the value of most businesses. If you have a registered trademark, then that, you know, can be quantified, put on the books by your accountant. It's not a depreciating asset like a patent or a design is a depreciating asset, so they can be used for accounting purposes, but you can still have that kind of, you know, on your books, and your accountant can help, you know, factor that in for all your accounting decisions. And when you go to sell the business, then it will hugely increase the value of the sale of the business if you have that exclusive right, and you can prove that you do by having a registered trademark. Yeah, so sorry, you asked me a little question and I go, blah, blah, blah. But, yeah, there are a lot of benefits to registering your trademark. It's really, I see it, you know, it's twofold. It's partly it's an insurance, but then partly it's an investment, you know, because it doesn't cost you that much to register your trademark. But if you can get exclusive rights and maintain those, then that's a hugely valuable asset. So
Yeah.
it's like a bit of a dual, I don't know what you call
dual
it,
benefit,
like,
dual focus there. Yeah.
yeah.
Very cool. I love all the elements there of what we need to think about, right? And the benefits behind it. That's really cool. And I know from my perspective that there's different classes of trademarks, right? So do you want to maybe explain some of these differences? Because it's not just, hey, I want to trademark this. There's actually a lot of different classes behind that. So can you share a bit more about that?
Yeah, so you mean like the goods and services are divided up into 45 different classes. So
Yes.
classes 1 to 34 are for goods, and classes 35 to 45 are for services. And that's an international system of classification. So that helps, for example, IP Australia to do a search, because if you say, well, I want to file for Athen Cassiotis in, I don't know, relation to class 35, like business advisory type services, then they can search for only the marks in class 35, which is already going to be a large number of marks. They don't have to search like the entire trademarks database for every single possible mark and see whether there's anything potentially related. So it helps them, I guess, to narrow their search and streamline that. So they will obviously still search beyond that particular class. They'll search for related classes, because when you get a trademark registration, it doesn't just protect you for those exact goods and services, that also protects you for goods and services that are, you know, same description. So it'd be things that are normally provided via the same trade channels or by the same manufacturers and bought by the same customers, etc.
Yeah. So
But yeah, that's what. Sorry.
yeah, that's all right. That's awesome. And just so an additional thing to that. So let's say I'm registering the name right under that 35 or whatever, but I want to sell merchandise, right? Like as an example, later down the line, and that would be like a different class, right? That you would have to register.
Yeah, well, so weirdly, because sometimes the classes are like, oh, it's a strange, combination of different products in or services in one class, but retail services is also in class 35. So you would only have to cover that one class, but you'd have to specify, business advisory services and retail services, and you'd have that all in class 35. But then depends what merchandise you want to sell, because if you want to sell, books, or if you want to sell, t-shirts or whatever it is, then those would also be presumably branded with the brand. So it doesn't have to be. There are some shops, like if you think, I don't know, I'm revealing my Gold Coastness, but City Beach, it's sort of like a surf store, but in City Beach, they would sell, Billabong and Quicksilver and stuff. So the brand of the store doesn't necessarily have to be that the merchandise in the store is the same. Like you wouldn't buy a City Beach, maybe you could, but you maybe wouldn't buy a City Beach bikini. You'd buy a different branded bikini at the City Beach store. So, if you were going to have Athen Cassiotis' store, but all the products and merchandise in the store were not branded Athen Cassiotis, then you wouldn't need to register for the goods. But if they were also going to be Athen Cassiotis branded goods, then you would also need to register for all of the classes that those goods are in.
Yeah.
Sense, yeah.
It does make sense to me. And yes, so that's the point, right? So it's not just one thing. You got to think ahead. And I think that's the same thing in business, right? Is what is this brand, that we want to trademark? What are we actually going to do with this later down?
Yeah, that's the thing. You should think ahead 3 to 5 years. So it takes a minimum of 7.5 months from the filing date to get a registration. You can't get it sooner than that. And the reason for that is that there's this thing called convention priority. So if somebody else filed in China, for example, they would have 6 months from that filing date in China to file in Australia, claiming priority from that Chinese one. And therefore, even though I might file today and they file their Chinese one tomorrow, they file their Chinese one today, I file my Australian one tomorrow. But when they file in Australia in like 5 months and 29 days time or whatever, they backdate to the Chinese one. So they're actually before me in Australia because they date back to that earlier priority date. So for that reason, IP Australia can't register mine yet, just in case in 6 months' time someone has actually pitched me that IP Australia didn't know about yet because it wasn't actually filed here yet. So you've got 7.5 months at a minimum till it goes through to registration. And then once it's registered, it stays on the register for 3 years before it becomes vulnerable to removal for non-use, because you need to use the trademark in order to maintain the registration. You don't actually have to physically hand over evidence of ongoing use. Like in the US, you do. You have to prove, evidence of use every, in the 5th to 6th year, and then every 5 years after that. But in Australia, you don't have to provide that evidence on a proactive basis. But if anyone comes along and they want your mark, you've been on the register for 3 years or more, they can apply for removal of your mark. So you've basically got from the filing date, if it goes through the quickest it can go through in 7.5 months, then from the filing date, you've got 3 years and 7.5 months to start using that mark. So you should think, what am I doing now? And what am I planning to do in the next 3 years and 7.5 months? Because if I'm planning to do it in that time frame, then I should file for it now. Because otherwise, if I wait until 3 years when I'm starting to get ready to do it, well, someone else might have got that mark already. So if you know you're doing it, think ahead. Your next 3 to 5 year plan, you should start getting those filings in today.
Nice. Yeah. And is there any do you have to like re-sign like after this period, or is it like indefinite once you've registered the trademark?
You can maintain a trademark indefinitely as long as you're using it,
Yeah.
and enforcing it too, because if you allow other people to just infringe willy-nilly and that becomes generic, then you can lose it. So there are ways you can lose it, but provided you're using it and enforcing it, you can renew it at every 10 years. So in that way, trademarks are a hugely valuable asset because it's an indefinite form of IP. You know, with patents, you get 20 years, um, designs, you get 10 years, but trademark or even copyrights, like 70 years after the death of the author. So that's even limited, but trademarks, you get it for forever. And so that's, a big reason why a lot of people try to get things that maybe didn't start off as a trademark, like the Coca-Cola bottle shape or things like that. If we can then get that registered as a trademark, whereas it might have originally been a design, but once it starts to operate as a badge of origin, then I can keep it a lot longer than I could have kept it if it was just as a design.
Yeah,
Um,
cool.
yeah,
Love that. Yeah, awesome stuff. I love all this. And one other thing as well is about structuring, right? Because where we register the trademark, I know is important. And I know there's a variety of options. For example, in Australia, we could do it under our PTY Ltd company that we have,
yeah,
or
yeah,
we could create like a separate trust where I've seen people register trademarks, in the trust there. So do you want to just talk a little bit about that and I guess the pros and cons around that?
yeah. Well, a trademark can only be owned by a legal entity, so it has to be owned by a person or a corporation. It can't be owned by a business and it can't be owned by a trust. Although it can be obviously beneficially owned by the trust, but legally it has to be owned by the trustee for the trust. So, if you want to file a trademark application, the most important thing is that you file it in the name of whoever is actually the owner of it at the time. So if you started your business as a sole trader, then you're the owner of it. You have to file it in your name. Then afterwards, if you do a business sale agreement and you transfer, everything into a corporation, then do that once there is a pending or registered trademark, because that then becomes an asset that's transferable with the business as a whole or separate to the business as a whole. And then I suppose because the IP is such a valuable asset, some people do like to say, well, I'll separate that out from the trading company and I will have a separate company that owns it. That's something to talk to your accountant about, because it does, the more companies you have, then you're going to be paying for, the company registration fee every year. And if you're not big enough and there's no merit to it, then maybe you don't need to do it. But if you are big enough and your accountant, it allows more flexibility then in your structure, to say, well, I can assign a license fee of this much from this trading company to that holding company, and then allows them to play with the money and where it's going, and therefore what dividends are payable, who's who are the beneficiaries under the trust, etc. So I definitely think that it is, the key things are it has to be filed in whoever owns it at the time. So that needs to be done. If you are, transferring it before it's been filed, you need to transfer it with the business as a whole. And when your accountant sets up a company, if you've been going from sole trader to company, make sure your accountant does a business sale agreement, or you get a lawyer to do that, because otherwise you're not documenting that. It's not clear whether that other business just shut down and a new business started, and therefore, this one entity, you abandoned the trademark and a new entity started that trademark from that date, or, whether there was continuity of use and there was a business sale agreement, but it wasn't in writing. So I think you just really need to have those legals really clear if you are changing structure. And then, talk to your accountant about whether there is that value in having different structures. If you have different structures, you do need all that formal documentation in place. Like you will have to have an internal license agreement. And the key thing with trademarks is that when you're licensing marks, there has to be control, because otherwise it's not clear that the trademarks being used by the licensee, and all the use is inuring to the benefit of the licensor, so that they maintain like all the use is theirs. So you need to exercise quality controls, and maybe just having some brand guidelines and making sure that the licensee only uses the trademark in alignment with those guidelines, and also financial control, so that you have the right to sort of audit what the licensee is paying in terms of royalties or annuities. And then not only do you have to have those on paper, but you actually have to enforce them. If you don't actually exercise your your right to control, then you could be said not to have it. But if they're related companies and there's same directors, then it'd be a lot easier to show that there was in actual fact control, because they were related parties. So it's not a huge risk for business owners that are just setting up internal structures like that.
Yeah. Cool. Awesome. Love that. Very awesome things to think about there. And there's a lot of talk now around the metaverse, right? And I know you're bigger on this as well, where it's not just business as we're doing normally, but it's like, what's this virtual world, so to speak, doing there? So what can you share about actions we can do to protect trademarks and things and selling our goods and services in the metaverse?
Yeah. Well, it's so hard to know what it's going to be like, because I've been playing around in the metaverse, because it's a topical issue for intellectual property law. I've just been appointed to the Queensland Law Society's Competition and Consumer Commission board, or committee. So I'm interested from that perspective of, people, obviously at the moment under the Australian consumer laws, if you have if a website and you're selling goods on that website, you have to have website terms and conditions that explain to your customer all of the returns policies, etc. But then if you're starting to sell goods in the metaverse, then obviously each metaverse has its own terms and conditions. So then is that enough that your consumers already have those terms and conditions, or if you have a shop within that metaverse, that you would also need terms and conditions for that? And it's not like a website, so how would you display those terms and conditions? If you have a shop in the metaverse, you have to display the terms and conditions of the metaverse on your website. You can have a look. Adidas, for example, are now starting to have terms and conditions available for their metaverse shop. So I think some of the sports brands are really kind of leading the way a little bit, like Nike's registered for downloadable digital goods. So, because all the people's avatars, they want to get kitted out in the cool gear. So that's sort of one of the first things. So anyway, I digress. I think if people are interested in setting up in the metaverse, then key is at least to register your brand for digital goods and virtual services, for example, that may not already be covered by your existing trademark registrations, because those sorts of things weren't front of mind to you at the time that you previously filed your application. So that's the first thing. And then the second thing is to start getting on there and start having a play, look around at what others are doing in that space, and then see how you could potentially be a bit of a leader in the market and space. And then just keep an eye out for legislative changes and things like this. As I mentioned, as lawyers, we're not even really sure how this will all pan out, and whether you will need certain terms and conditions that are different to what we all already know that you need. That maybe just saying, oh well, at the very least, why don't we modify our existing ones to best account for our metaverse activities for the time being, and then if we get more guidance as time goes on, then we can keep updating those. But
Nice.
Yeah, that's sort of where I'm at. I'm really like I'm quite interested in that and in AI and still crypto as well, because I hear other lawyers saying, oh, should we start accepting payment in cryptos, particularly people that are dealing with divorce, because a lot of the younger generation, their money is tied up in crypto, so that's what they have to offer as a form of payment. But then, I've just pitched it for the Queensland Law Society's Gold Coast conference as a topic for discussion, because how would that work with our trust accounting requirements? With the Queensland Law Society audits every law firm every 3 years, and I'm sure there's New South Wales one would do the same, etc. So does the Queensland Law Society have the ability to audit lawyers' wallets for trust accounting purposes and make sure that you're doing the right thing from a crypto perspective? I think that would be too much for that. But then if you can't hold money in trust, it's a massive risk, and so it might turn a lot of lawyers against crypto as a form of payment. But that becomes like an ongoing thing, because each of these metaverses has their own form of digital currency. So if people, businesses are trading in the metaverse, they're going to be generating digital currencies that are not necessarily cash. So if we want to work as lawyers for companies that are trading in the metaverse, then, we're going to have to get on board with that.
Yeah.
Yeah.
Yeah, no, it's so interesting. There's other areas, and yeah, interesting that people are creating these areas and what we need to think about. You mentioned a couple of things there. Was copyright and AI, and yeah, this is big now. Obviously, AI is taking over ChatGPT,
Yeah.
doing a lot of things, and people using it. But let's do a double prong question, and just generally, what do we need to know about copyright, but then also in conjunction with AI and copyright as well?
Yeah. Well, the key thing for just not cutting edge stuff, just everyday stuff that's probably more relevant to most people than the other stuff, but is just copyright can only be assigned in writing. If it's not in writing, it's not assigned. So you can say, well, it's been beneficially assigned but not legally assigned. That's the same as like a trust can have beneficial ownership and not legal ownership. So you can get a confirmatory deed of assignment to transfer legal ownership later. It becomes messy, and especially if you filed a trademark application. When you file the trademark application, one of the criteria that IP Australia uses in order to determine whether it's registrable is to say, well, its use wouldn't be contrary to law. But if you're not the owner of the copyright, then essentially use would be contrary to law, because it would be copyright infringement to use that mark. So you really should be quite careful to make sure that copyright and trademark ownership of logo marks is going together, and make sure that you acquire that right to ownership in writing from the graphic designer, or also from the software developer, because they're the two key pieces of copyright work that I work with most of the time, is source and object code and logo marks. So that's really what everyone needs to know. At the moment, copyright it's an artificial construct like anything in the law, but copyright really, it's an intangible. It's something we've decided what it is and when it's generated. So under the law of most countries in the world, copyright is created by a person. So if something's created by artificial intelligence, then as it stands currently, there isn't copyright ownership in that. That then, causes some issues, because, I've had matters where somebody's generated something by AI in the US, and then someone's generated something very similar by AI in Australia. And if the US person under US law doesn't own copyright because they weren't the creator, it was the AI that actually created it, then they don't have an enforceable copyright right to stop the Australian person from copying. So maybe like not advertising that something was created by AI, because then people won't know that they're free to just copy it willy-nilly without infringing any person's copyright. That's, you know, a possibility.
Yeah. Or you could potentially use the AI to get a base structure, but then adjust it, right? If you're and that would be then individual copyright.
Yeah.
Yeah.
And the thing to you know, to just double check your facts on that AI. Like, I know there's this issue with defamation now, because ChatGPT just created sort of a scenario about a US law professor that wasn't actually true. So you know, because it pulls different information, and that's why they say it doesn't cause copyright infringement, because it creates something new itself based on everything it's amalgamating. But then that something new might not necessarily be new and true. You know, and same for lawyers using it. They're finding that it was inventing case names and things like that. So it wasn't really a reliable source of research. Yeah, but I guess, as you say, if they modify it, then that's a good way to then say, well, you know, that was therefore my creative work, and if anyone copied that, it would be copyright infringement.
Yeah, nice. And one thing you sort of touched on a little bit, but I think it's important, is about website terms and conditions. I know I've got mine at the bottom there, and it's important. So yeah, why is it important generally to have it? I know you mentioned a little bit about the metaverse having their own, but generally website terms and conditions. Yeah.
Well, I think just to make sure, you know, if someone went to your website and then they got some sort of virus from your website, that you've already made it clear that people are visiting your website that are at their own risk. If they link from your website to another site, that you make it really clear that, you know, that other site may use different cookies to you. Maybe someone's accepted your particular cookies on your website, but when they go there, you're not liable for whatever privacy violations that other site might engage in, so that you're not endorsing anyone by having a link. And you make it really clear that your content is your own you know, copyright work and your own trademark, so that no one's allowed to just take works from your website and repost those. It sounds like you know, something that doesn't really have to be said, but yeah, I have people that have YouTube accounts and they're creating amazing content, and then people are just cropping their little logos out and just reposting that content onto their own website. So, you know, some people may be doing that because they just don't care about infringing other people's rights, but to the extent that people just don't understand, then, you know, just having that there to educate. And also, you know, if it does go to court, then, you know, you can show that the infringement's more flagrant, for example, and you can seek things like additional damages if it was really clear that you know, you claimed exclusive rights over those particular things, and that someone was made aware of that and then they, you know, infringed it anyway. Yeah, so I think those are really key things that everyone, doesn't matter if you're providing a retail service. I mean, you know, if you're retailing goods or whatever, and you'd have to have it for the ACL, it's still important for so many different reasons, just to protect yourself, because it's like somebody coming into your premises. You know, everyone would say, well, when you come into my premises, you're covered by, you know, particular type of insurance, but you know, you have to act in a certain way, or else you won't be allowed to remain here, and things like that. So it's just sort of setting up those conditions for how someone is allowed to use your website and on what basis.
Yeah, nice. Awesome. Very valuable. It's been definitely a jam-packed value episode today. And as we're getting towards the end now, I always love to ask, what key piece of advice would you like to give to all the entrepreneurs watching and listening today?
I guess what I would like everybody to think about is the brand that they pick in the first place, because a lot of people, if they're adopting a new brand, they want to choose something that explains what they're doing, but then it becomes a bit of a difficult mark to register, because descriptive marks are not registerable, because anyone is entitled to use a mark to describe their goods and services. So you need to pick something that's more, Amazon. It doesn't say anything. That doesn't mean anything about an online marketplace. Apple doesn't mean anything about computers. Those brands that don't mean anything about the goods and services, they are registerable without spending a lot of money. Because if you do choose something that is descriptive, it's possible to overcome that, but you need to submit evidence of use to prove that it has acquired distinctiveness through use. But then, so once you get that sort of descriptive mark through by providing the evidence of use, then it's a lot harder to police, because I wouldn't be able to just set up a Google alert for my particular brand, and if it's really unique and if it pings, then I know, hey, someone's used that. Oh, I didn't authorize that, and you can send out a cease and desist or something. It's a lot harder to determine, when the infringing use is occurring, and then people will often have two defenses. They'll say, number one, no, I didn't use it as a trademark. I was using it to describe my goods and services. So it's only trademark infringement if I'm using it as a trademark. So they'll deny that there was infringing use. And the other thing is they'll threaten to apply for revocation or cancellation of your registration on the basis that it should never have been registered because it doesn't act as a badge of origin because it's descriptive. So it's always harder to get descriptive marks, and it's harder to police descriptive marks. But once you've used a descriptive mark for 5-10 years, and then I come along and say, hey, time to register your trademark, and then I'm like, oh, that's not a good one. But it's very hard to change then after 5 to 10 years. So it's really something to think about at the get-go. And people want to use the descriptive one because they think it's going to be better for marketing and advertising, because consumers will immediately know what you're providing. But then if you think about, if I meet you at an event and then I'm looking for you again, and I'm like, oh, business coach, who's a business coach, that was his name of his business, and I'm searching business coach, I'm going to find 10,000 different ones. Whereas if you tell me, I meet you at an event, you tell me a really unique thing, I write it down or I remember it and I look for that online, I'm going to find you. Like it, even in an early stage business, I think that cutting through the noise of the internet by having a more unique mark makes you more findable and everything. It is, I think, better. I don't know where that whole descriptive, people thinking that they need a descriptive mark and that's going to be more valuable. I don't know where that comes from, but from a trademark attorney's perspective, it's not right at all. So yeah, that's my advice. Yeah.
Yeah, awesome. I love that. Really powerful thinking of when we're creating our brand or at the start of our brand to really set us up well for the IP trademarking. So yeah, love it. All very powerful. And yeah, we connected through our network. So I learned about your awesome journey from being a law graduate to now, being the founder, owner, and director of Tar Law. Amazing woman, very knowledgeable. And I'm sure you continue to help people with their trademarks, designs, patents, plant bidders' rights, copyright, and domain name matters. I'm very grateful that we connected and look forward to working with you. So how can people find you, get in contact with you?
The best thing to do is find me on LinkedIn, Hayley Tar. I love connecting with people on LinkedIn. That's how we met. So if they find me there, otherwise, my email is hayley@tarlaw, tarlaw.com.au, and then my website, tarlaw.com.au. So, my phone number's on there. Yeah. I guess hopefully that's enough ways to find me, get in touch with me, Google me, Hayley Tarr, I'll come up.
Yeah, love it. Definitely check out Hayley. Yeah, in all those different areas that she's mentioned, with anything IP and trademarking that you need there. And thank you to everyone for watching and listening to this show where we talk about everything on business growth. And please like, subscribe, and leave us a 5-star review. You can find me on LinkedIn, Facebook, Instagram, and YouTube as Ethan Casiotis, or visit my website, ethancasiotis.com. And if you want to grow and scale your business, you reach out to me on any platform to see if we're a good fit. I completely agree with you, or do I? The only way we know is if you tune in next time. So until next time, remember that our business grows when we learn skills and take action using them in spite of fear. So remember to design your growth and results.